this is yet another step to really bring knowledge to the doorstep of people, and is very, very appreciable, because there are so many humongous changes that has come in the month of December. Anyways, whenever we look at SEBI, we are so much aware that because it has got the right set of ears and eyes, it keeps listening to its stakeholders and also what's happening in the economy, and tries to make it as robust as possible. So in that league of things, there have been n number of changes that has come up in December. Without much ado, let me straight away go into the session, because there are two things to cover, and not much time that we can take of the people who are here with us today. So I'll straight away take you to the presentation, and here it is. First, let me take you through the LODR changes that has occurred. It has happened on the 12th of December by Third Amendment Regulations 2024. Now, let me first tell you the few things that is important. And apart from that, this presentation contains all of it, which will be shared as mentioned by her. Now, the amendments has taken effect from December 12th. However, there are specific amendments which has to come into force from December 31st, which has already gone by and it has come into force now. So whenever you're looking at the presentation, you'll have to be careful about that. Few highlights. Definition of half year has been removed. Not that it has made any difference, but probably it had not much relevance, so the definition has been removed. Every slide will carry as to why the changes has been occurred. Some of the changes has occurred because it has lost relevance over a period of time, and some has been done so as to keep speed with the changes that has occurred during the past few years. The definition of related party has changed. RPT, that is related party transaction, is something which captures 80% of our mind whenever we are doing anything with regard to listed companies. So there have been few changes with regard to RPT, which we need to take care of. So these are all positive changes. In RPT, what they have done is, if you see the first point, it is more so applicable for banking companies. Acceptance of current account deposits and savings account deposits by banks in compliance with directions issued by RBI or any other central bank will not be considered RPT. See the second point that is quite relevant for us in day-to-day practice. Retail purchases, which is made by the directors or employees of a listed entity or its subsidiary, without establishing a business relationship, and if it is done under terms which is uniformly applicable to all employees and directors, will not be considered RPT. For example, say for example, we are in Vishal Mega Mart company, and the directors or the employees of Vishal Mega Mart is buying something from that company, and if that purchase is not due to any business relationship and it is under terms which is uniformly applicable to all employees and directors, this will not be considered RPT. Even the LODR has now included the definition of SR equity shares. So I'm sure you're aware of this. SR equity shares definition has already been there in the Companies Act also, but senior rights, it is now being brought into the LODR too. The compliance officer must now be an officer in whole-time employment. So we cannot have compliance officer who's not in whole-time employment, and it has to be one level below the board of directors. And compliance officer also now needs to be designated as a KMP. It now goes on to say that any vacancy in the office of the compliance officer, if a resolution plan has been approved, must be filled within 3 months of such approval. 5 to 6 points have been added with regard to NCLT approvals that takes place for listed companies. And there they have put timelines in place that if NCLT is giving approval to any resolution plan of a listed entity, what is the timeline within which fill up of vacancies needs to be done? In most of the places, it is 3 months. And then some of the certificates, especially in 3 places, the certificates have been done away with because it has lost its relevance. If you recollect, there were these certificates which had to be given every half year, where transfer, transmission, etc. had to be confirmed within a certain given point in time and within a given time frame. That has lost its relevance because now everything is in Demat mode, so on and so forth. So 3 kind of certificates has been removed because of losing its relevance, and it was a repetition. Investor complaints, etc. If you recollect, now we give them the investor complaints in a format that what was in the beginning of the year, that is the opening balance. what came in the middle of this 3 quarters, I mean 1 quarter, and what remains pending. Now that format is going to change, and the new format is yet to be given by SEBI, but when that comes, that will be applicable. And it goes on to say many changes has occurred with related to secretarial audit. You may have to be very careful while doing so. Secretarial audit, which will now become applicable for the audit of 2025, that is 31st March 2025. For all of this will be applicable. So we'll have to be very, very careful. Now, for 2025, I understand that, some appointments has taken place. So now, whatever appointments you are doing for in the calendar year 25, for the years 25 to 26, and henceforth, that has to be taken care of as per the latest provisions. Secretarial auditor now will be appointed by the AGM. That's a very, very good change that has occurred. And secretarial auditor has to be peer reviewed. Even the firm has to be peer reviewed. The signing partner, whoever signs the secretarial audit report, will also have to be peer reviewed. All that has come in the provisions, and how the casual vacancy will get filled up, etc., has also been incorporated in the provisions. So the eligibility criteria, qualifications, and the disqualifications have been provided. Like, for example, a statutory auditor cannot do certain things if he is as a statutory auditor. Similarly, for the secretarial auditor also, what you can do and what you cannot do has been given. The SEBI will now specify the format and timelines for submission of quarterly compliance report and disclosures to stock exchange, but must now be in XBRL format following the guidelines specified by the exchanges. It goes on to also change and say that listed entities now need to intimate the stock exchange at least only 3 days in advance for the record date. You know that this requirement was earlier of 7 days. So the corporate actions has been facilitated by reducing the number of days. It also goes on to say that if the general meetings are being done only by electronic mode, then there is no sense of giving proxy forms, and therefore that provision has been done away with. And it again, as I told you, that the requirement to file a certificate certifying all certificates for transfer, etc., have been done away with because it has lost its relevance. Now, this was something which I thought I'll give you an overview. There have been, as I was mentioning, a lot of changes. So we have kind of tracked it regulation wise. I'll have to quickly go through it because there are certain changes which has also been brought about by the board meeting of SEBI in the month of December. So it will be also important for you to go through that. So very quickly, Regulation 2, half year, as I mentioned, I'll go through it fast, give you kind of a bird's eye view, and this presentation will be with you. This is a very detailed presentation that Taxmann will share. Now, if you see that there have been changes in Regulation 2, what we have done is we've put up a slide to say what are the changes. Because if you see the notification, the changes are always given in these many words. So it has been important to track it. Now, the related party definition has been changed. Okay, has been amended. What has been done? Not much. But here, if you see, look, this is how it is. Then it says the following corporate actions. They have deleted the words by the listed entity. What we have done is we have tracked it in track changes mode so that it is easier for you to see. Okay. Now, new clauses, as I had told you about the current deposits and the retail purchases. Then securities law definition has been changed and not much has happened. If you see the green ones are the inclusion. The red ones in track mode, which is struck through, are the ones which has been deleted. So if you see, it is more of a language change, not much. SR equity shares, as I was telling you, it is already there in the Companies Act. The Companies Act also talks about in Section 43. So this definition has been kept in sync with the Companies Act. And I'm sure you're aware, Regulation 41 also talks about SR equity shares. So SR equity shares means equity shares of a listed entity having superior voting rights compared to all other equity shares listed. Now, this is, if you see, we've also tracked it chapter-wise. Now, Regulation 5. Regulation 5 is very important. It deals with general obligation of compliance. So here, a very good change. Just look at it. The green one is the new inclusion. It says that the listed entity shall ensure that KMP, etc., complies with responsibilities or obligations, if any, assigned to them under these regulations. This we are aware. But now they have gone ahead and said that the promoter, look at this, promoter promoter group, they have also included the word promoter group, or any other person dealing, shall disclose to the listed entity all information that is relevant and necessary for the listed entity to ensure compliance with the applicable laws. So even the burden has also been put on the promoter and the promoter group, etc., that they have to disclose to the listed entity all the information that is relevant. So that's quite welcome change. Compliance officer and his or her obligations, as I've already told you, that cannot be more than one level below, lower than more than one level below the board of directors, and it has to be designated as KMP. Then if you go on to Regulation 6, as I was mentioning, that it has to be filled in within 3 months of such approval by the NCLT. Share transfer agents. Now, in share transfer agents, what they have done is this provision has been totally amended by making it omitted. Why? Because it has lost its relevance at all. Now, within 30 days, you do not have to certify any such requirements. Regulation 10 is about filing of information. Here, new sub-regulation has been added where it talks about integrated filing. So the board may enable integrated filing of periodic reports. Okay. Then we go on to Regulation 13, which talks about grievance redressal. As I had told you that the format will change, and whenever it comes, that will be applicable. Then in Regulation 15, what they have done is they have, if you see the green one, they have also included 26A. Okay, they have included 26A. If you recollect, Regulation 17 to 27 and the other clauses of 46 and para C, D, and E are not applicable to such entity. Which entity? A listed entity having paid up equity share capital not exceeding rupees 10 crore and net worth not exceeding rupees 25 crore. So for these entities, these provisions, which has been written with all commas, is not applicable. Sometimes we colloquially just say that it is not applicable to a SME listed company. But let's be very careful while saying that, because SME listed company can be up to a paid up equity share capital of 25 crores. But here, the non-applicability is only up to the extent of having paid up capital not exceeding rupees 10 crore and net worth not exceeding rupees 25 crore. This thresholds have not changed. So just be careful about that. And there are some similar changes that has occurred in the provisions which is coming below that. Then it goes on to say that here, as I told you, for NCLT approval of resolution plans, there have been 5 to 6 places where provisions have been added that compliance has to be ensured within 3 months of the approval of resolution plan under Section 31 of the Insolvency Code. Now, if you see these regulations where we are dealing with audit committee, NRC, stakeholders, and risk management, a very similar change has been brought out in all of it, and that is if you recollect, it says that it talks about the meeting, the duration of the meeting, etc. Now we say that for minimum one meeting needs to be done. For risk management, two meetings needs to be done. For NRC, at least 2 meetings to be done. For audit committee, 4 meetings to be done. Board meeting, at least 4 meetings needs to be done, and the gap, etc. Now in that year, they have included the word financial. So that's one of the basic changes that has come, and that change has come over in all the committees and also for board meetings. So they have made it very clear that it's not a calendar year, it's a financial year. Okay, now in Regulation 16, obligations which has listed its specified securities and non-convertible debt securities. So there have been a change in the definition of material subsidiary and for senior management. Please be careful while you read this. Chapter 4, the definition changes has occurred in Chapter 4, which is for companies whose specified securities and non-convertible debt securities are listed. So you have to be very careful while you read this. What has happened, the major change that has come about is that the definition has been changed to include the word turnover, rather substitute the word turnover instead of income. So now material subsidiary shall mean a subsidiary whose turnover or net worth exceeds 10% of the consolidated turnover or net worth. So what is it I'm saying? That instead of income, now you need to ascertain by way of turnover. And this is in line with the international norms, and also because of the GSTI, and it is backed, turnover is quite backed. And then it goes on to say that if you see this, you'll be getting a better clarity. For senior management, as I was mentioning, definition has changed. For senior management, what they have said is, here the words company secretary and the CFO Instead of this, they've struck off this and they said persons identified and designated as KMP other than the board of directors by the listed entity. So they have made it wide encompassing. In a lot of changes has occurred, if you see in Regulation 17, which deals with board of directors, very quickly, that if you know, I'm sure you're aware that if a director is attaining 75 years, they need a special resolution, etc. And the explanatory statement should also cull out every such detail as to why we are looking forward to appoint a director who has attained 75 years. Now they have come out with very much clarity and they say that the listed entity shall ensure compliance with this sub-regulation at the time of appointment or reappointment or any time prior to the non-executive director attaining the age of 75 years. You know why this has come is because sometimes we had seen that in the middle, the person was attaining 75 years, and then there used to be a lot of issue as to how to go about it, and there used to be a non-compliance. But now the listed entity, it has been culled out in the LODR itself that it has to happen prior to the non-executive director attaining the age of 75 years. And it says that any such reappointment, etc., not only of the 75 years, but if it is needing any approval of the regulatory, government, or statutory authorities, then the time taken to receive such approval shall be excluded. And such changes has happened, like provided further, provided that, because when the changes are happening in the upper clauses, so it is realigning the provisions by adding further or by removing further. Okay. Now, let's see what has happened in the second, third, and fourth proviso of Regulation 17. See, what I've done is, if you see the changes, it is in green. So because it has become a sub-regulation, so they've included the word sub-regulation. So you see the changes when you're going through it. Now, as I was mentioning, that for the NCLT provisions, etc., not later than 3 months, and even otherwise, even for non-NCLT, the LODR only gives you 3 months' time. See here, if you talk about board of directors, Regulation 17 is about board of directors 4 times a financial year. Okay, 4 times a financial year and 120 days between any 2 consecutive meetings. Though we knew that very well, but now it has been properly spelled out. So everywhere the financial year word has been included, and wherever it says that about the explanatory statement, they also talk about the rationale to be added on each of these specific items. I'm sure you're aware that even the Companies Act has already mandated that rationale has to be given, but now it has also come into the LODR. So now this amendment is in sync with Section 1021B of the Companies Act. How? See, any other information and facts that may enable members to understand the meaning, scope, and implications and to take decision thereon. This, in so many words, means that one has to give the rationale. As I was mentioning, for audit committee, see, consecutive and financial word. For NRC, shall meet at least once in a financial year. Stakeholders shall meet at least once in a financial year. Risk management shall meet at least twice in a financial year. So all the green ones are the changes. Then the related party transactions, these are the changes that has come. Now, in the related party transactions, look at the change. This is quite an important change, and it will give you some relief also that now, and please see it carefully, remuneration and sitting fees paid by the listed entity or its subsidiary to its director, KMP or senior management, okay, to its director, KMP or senior management, except who is part of promoter or promoter group. Now you need to mark these words. So if it is being given to a managing director who's also a part of the promoter or promoter group, even if 1 rupee is being given by way of a remuneration or sitting fees, etc., that will anyways be termed as related party as it is being done today. But if the remuneration is being given to a CFO or CS and the person is not related and is not part of the promoter or promoter group, and if it is not material in nature, then we need not be terming this as a related party. So this is quite a big change that has come, and this is giving a lot of relief to the companies. So remuneration, so where is it? Look at this. Sub-regulation 2, after the addition of the new clauses. So we are going through all related party transactions, and subsequent material modifications shall require prior approval of the audit committee of the listed entity. Right? I'm going through that. In that, a clause E has been added that remuneration and sitting fees paid by the listed entity or its subsidiary to its director, KMP, or senior management, except who is part of promoter or promoter group, shall not require approval of the audit committee, provided that the same is not material in terms of the provisions of sub-regulation 1 of this regulation. Okay, so which means it is now what we are talking of is whether these will require prior approval of the audit committee of the listed entity or not. So what it is saying that it does not require the prior approval of the audit committee. In fact, it does not require approval of the audit committee if the same is not material. Then it says it has also given some powers to the audit committee to go on to say that up to 1 crore, it will have power to ratify the related party transactions. It may so happen that, hurriedly something has happened or something may happen wrongfully that we are not aware that it was a related party transactions. So to capture such situations, this F has been added. Very quickly, if I read it, the members of the audit committee who are independent directors may ratify, please mark these words, may ratify related party transactions within 3 months from the date of the transaction or in the immediate next meeting, so on and so forth. Okay, rationale, etc. has to be given, and 1 crore limit only has been given, not more than that. Look at point number 1. During a financial year shall not exceed rupees 1 crore, individually or taken together. Okay. Now then regulation 23, some changes has happened. Audit committee may grant omnibus approval for related party transactions proposed to be entered into by the listed entity or its subsidiary. So this is also a welcome change, or its subsidiary has been included. See, this the provisions of regulation 23 related parties transaction, it will not be applicable to transactions entered into between two public sector companies. Previously, the word government companies was there. They've excluded it. Government word has been omitted and public sector has been included. And then they have added all of these, that transactions entered into between a public sector company on one hand and the central government or any state government or any combination thereof on the other. And also there is a provision with regard to statutory charges and statutory fees. Now, as this is almost, I have already mentioned it to you. 24, regulation 24 is corporate governance requirements with respect to subsidiary of listed entity. Now here also the word income has been replaced with the word turnover and or net worth. Okay, so material subsidiary for the purposes shall mean a subsidiary whose turnover or net worth exceeds 20% of the consolidated turnover or net worth. And please mark the words or, it's not an and. Okay. See, this is a new inclusion, which is quite the corporate sector is quite hailing this, that nothing contained in this sub-regulation shall be applicable if such sale, disposal, or lease of assets is between two wholly owned subsidiaries of the listed entity. Secretarial audit, I have already told you in brief. All of it, I have put it in the slide. It will take a lot of time if I go through each of the slides, because I have to also tell you what's happened in the board meeting of SEBI. Now, what about regulation 25, obligations with respect to independent directors? Now, this has been omitted. Now, this only means, if you read it, it only means that the replacement should happen within 3 months. Why it has been removed? Because independent director is also a director. So they have not treated this separately. Because independent director is also a director, it is included in the normal provisions of directors. And that's the only reason why this has been omitted. So don't wonder as to all of a sudden why it has been omitted. Okay, then obligations with regard to employees, including SMP, KMP, directors, and promoters. Now here it says that all interested persons involved in the transaction covered under the agreement shall abstain from voting in the general meeting. So what is this agreement all about? Whatever agreements, if you recollect, see what I have removed it. Provided that what is it? No employee, including KMP or director or promoter, shall enter into any agreement for himself on behalf of any other person with any shareholder or any third party with regard to compensation or profit sharing in connection with dealings in the securities, unless prior approval for the same has been obtained from the BOD as well as public shareholders by way of an ordinary resolution. So what it goes on to say, the second paragraph, which is about provided that, this has been removed because it was from the coming date of coming into force of this sub-regulation, 3 years. So all this has lost its relevance. Now it goes on to say, provided that all interested persons who's involved in the transaction shall have to abstain from voting in the general meeting. So all that has been included here. Vacancies, 3 months, let's just, and for wherever there is a NCLT thing that has happened, 3 months from the date of approval of the resolution plan. Other corporate governance requirements are there. The listed entity shall submit to the recognized stock exchange within the format and timelines. Nothing much to really talk about. The format of quarterly compliance report has already there. What has been removed is details of all material transactions with related parties. This has been deleted. Now you may think, oh, that does it mean that material transactions with related parties need not be disclosed? No, it's not that. I think they have done away with because it was a duplication, because the format of quarterly compliance report already anyways carrying the details of the RPTs in point number 5 of the set format. So that is the reason why they have probably removed it. Everywhere, we've tried to find a logic as to why it has been done. Now here, if you see, this is Regulation 30. Regulation 30 is something which is with us all the time. We are aware that Reg 30 is an omnipresent regulation, because everything and anything we first need to check Regulation 30 or Reg 30 as we call it colloquially. So this is a very, very important change that has come. And very quickly, if I have to tell you, it says that, say, for example, and this you may give me a years, like a board of directors have, say, for example, closed its meeting post the normal trading hours of that day. Okay, so then what happens? So it goes on to now actually define it. What is the existing provision? 30 minutes from the closure of the meeting of the board, right? But now it goes on to say that if the board of directors meeting has closed after the normal trading hours of that day, but more than 3 hours before the beginning of the normal trading hours of the next trading day, the listed entity shall disclose the decision pertaining to the event within 3 hours from the closure of the board meeting. Let me give you an example. See, if the meeting, see, look at the example. If now here I've put it, according to the SEBI, the normal trading hours for the Indian stock market is 9:15 a.m. to 3:30 p.m. Monday to Friday. Thus, if a board meeting is concluded during normal trading hours, then the disclosure must be made in 30 minutes of the conclusion. And if the meeting is concluded after trading hours, then it has to be disclosed within 3 hours. So, example, if the meeting is concluded at 11 a.m., then disclosure has to be made by 11:30 a.m. And if the meeting is concluded at 11 p.m., that means at night, then disclosure has to be made by 2 a.m. next day. Okay. Okay. Then here there's a small change of complete. The word complete has been removed. I'm not going through the small changes because we don't have so much of time today. Regulation 31A, there are some conditions for reclassification of any person as promoter or public. Lot many changes has come here. See, these many changes have come. Now, if you ask me really what are the major changes, nothing much really. It says that does a prior approval required, how the application needs to be filled in, how will the application be replied by the exchange, so on and so forth. It is for both the promoter wanting to go for a public reclassification and the public wanting to go for a promoter reclassification. So it's more about the process which has been laid down. So the red ones have been struck off and the green ones have been added. So here the resolution from the shareholders will now be required post the receipt of NOC from the concerned stock exchange. This is one big change that has happened, which is quite welcome. And promoter groups have also been taken in its fold. Whereas it was earlier promoter, now promoter groups have also been included. Okay. And some of the repetition have been done away with. Now here, if you see, it is Regulation 31A, small changes. These are the changes that ought to have occurred, which has occurred. It shall be required to be making an open offer. Now it simply reads, it shall make an open offer. So these are the small changes that has also occurred. Here, previously it wanted to tell you in the regulation that you have to share the minutes. Now it says, okay, you just share the outcome. So minutes would otherwise was meaning that, you need to share everything, but now you need to share the outcome. So these are the small changes that has happened, but which is very welcome. Now here, if you see that it talks about Regulation 31A10, also this is all about reclassification, how and when the process has been laid down. Regulation 33 is about financial results. You'll be happy to see the change, I'm telling you. See, provided that listing for a resolution plan, if it is there, shall disclose its financial results within 90 days. So when a company is into insolvency process, okay, and where, see, in respect of which a reso plan under has been approved, it goes on to say that then the provision of 45 days will not be applicable. The provision will become that of 90 days from the end of the quarter in which such resolution plan was approved. Here also about the insolvency code, and it talks about the last quarter, that is the audited one, that you need to, then you will get about 120 days. Previously, it was 60 days. Annual report. Annual report, it says that, see, for annual report, lot many changes has also come. And it goes on to say that the listed entity shall submit to the stock exchange and publish on its website a copy of the annual report on or before the commencement of dispatch. So it's more of an English correction. Not that it was wrong, it's just that they've made it simpler. Documents and information to shareholders, very welcome change. Now look at this. The listed entity shall send the annual report in the following manner to the shareholders. What was it? Apart from the point number A, hard copy of the statement. This is a very welcome change. A hard copy of statement containing the salient features of all the documents as prescribed in section 136 or rules made thereunder. What they have now said, a letter providing the web link, including the exact path where complete details of the annual report is available. Okay. Then it goes on to say hard copy of full annual reports to those shareholders who request for the same. The listed entity, okay. Then in these secretarial auditor word has been included, draft scheme of arrangement. It goes on to say that you need to provide the draft scheme before you file it, because why do I say this? Because the word draft has been included. Okay, so the draft simply means that you need to give it. But then what it says, nothing contained in this regulation shall apply to draft schemes which solely provide for merger of a wholly owned subsidiary with its holding company. For this, you need not supply the or need not send to the exchange, need not apply also to the exchange with the draft scheme, solely providing for writing off the accumulated losses against the share capital of the listed entity applied uniformly. Okay, this is for reduction of capital, but the caveat is applied uniformly across all shareholders on a pro rata basis or against the reserves of the listed entity. So the word draft has been used. That means it is a prior disclosure. And this has also widened the ambit to include reduction in share capital. So this is quite welcome. So it says nothing contained in this regulation shall apply to draft schemes, which, as I told you, the 2 points. Okay, and regulation 39 is all about certificates, etc. So a small change. The listed entity shall effect issuance of letter of confirmation rather than talking of certificates. The red ones, when you see, it means omitted. Okay, the red ones have been omitted. So don't get confused as to what is it that I'm trying to say. Now, on the transfer and transmission front, lot of provisions, if you see this slide, has been omitted because transfers and transmissions, etc., and so much is happening through the Demat mode. So wherever this physical thing was there, all has been omitted. So all the red ones has been omitted. Okay, all has been omitted. Now, the regulation remains. Don't get confused with the regulation there or not. Like you see, regulation 2, 3, 6, 8, 9, and 10 has been omitted. So 1 is there, 4, 5 is there, right? So these provisions has been removed because the shares of listed entity are now mandated to be in Demat form. Thus, with time, these provisions have lost its relevance. Record date also, as I was mentioning you in the beginning, that from 7 days, it's become 3 working days, and corporate actions, etc., provided that in the case of corporate actions through schemes of arrangement covered under Regulation 37, shall give advance notice of at least 7 working days. That has been increased from 3 working days. Regulation 42C, the listed entity shall ensure the time gap of at least 30. It was 30. Yes, you're reading it quite right. The 30 has been made 5 working days. So my comment is this facilitates corporate action. All the red ones has been removed. Meeting of shareholders and voting. As I told you, proxy forms will not be included if the meeting is solely done by way of electronic mode. Website, there have been some changes, deals with website. The listed entity shall disseminate the following information under a separate section on its website. It has to put up the memorandum of association and articles of association, brief profile of board of directors, including directorship and full-time positions in body corporates. Please note these changes, it's very important. And it also says, this is also very important because all of us are going through this every day. Presentations made by the listed entity to analysts or institutional investors meet post earnings or quarterly calls, but prior to the beginning of such events. Okay, this we need to give. And then there is again a change in Regulation 46. If you see Regulation 46, there's a very interesting change that audio, look at the changes. Audio or video recordings, if any, simultaneously. Okay, it used to write the simultaneously, but what it now says, the audio recording shall be promptly made available. The video recordings, if any, shall be made available on the website within 48 hours from the conclusion of such calls. And the transcripts of such calls shall be made available on the website along with simultaneous submission to the recognized stock exchange. Okay, this is the change. But this is the most important point that I wanted to tell you. The other changes, you may be able to track it. Here, you may see that these documents were earlier classified as permanent information to be hosted by the entities on its website. But now it has been reclassified as temporary information. Why I say so? Because of these regulations, I've gone through it in details, and now I understand that this is the change. You may also kindly see it at your end. Now, there's a change in Regulation 46. The new clause ZA talks about employee benefit scheme documents. Okay, and so these amendments which has come with regard to that, you may kindly see the changes. Even if you're doing a redaction, you have to mention it. Redaction means you are taking it back. Advertisement in newspapers, there have been certain changes where it now says that you do not need to write or disclose all the figures in the newspaper by way of publication. You can also do it by way of by way of the QR code. So this is the change. See, previously it used to say that financial results has submitted both standalone, shall publish consolidated financial results along with turnover, profit, so and so, with a reference such as the website, etc. But now it goes on to say that the listed entity shall publish, this is a very important change, shall publish an advertisement in the newspaper within 48 hours of conclusion at which the financial results were approved, containing a QR code and the details of the web page where complete financial results of the listed entity as specified in Reg 33 along with the modified is accessible to the investors. But then they go on to say that nothing precludes a listed entity from publishing if it so chooses. So red ones all have been removed. Okay. So these are the changes that has been brought about in the LODR. Now let me take you through the changes that has been brought out by way of the SEBI board meeting, and some of the changes which you will see has not still come into effect, but they are very soon going to come into effect. Just give me a moment. I'm not able to just see the file. 1 second. Yeah. SEBI board meeting. Very quickly. This also I'll share it with Taxmann so that they can share it with you. And very, very interesting. The SEBI actually, while its 208th board meeting on December 18, they have introduced several significant regulatory reforms. And let us understand that it is all aimed at enhancing market integrity and investor protection. I'm sure you're aware that because of SEBI's actions, not today, but even in the yesteryears, India is being considered as one of the quite robust and a market which is dedicated to investor protection. At the same time, it is also developing the market. So we are very, very fortunate that we are at times where SEBI is lending ears to everything that's happening in the market and trying to capture any deficiencies that is coming to their notice. Now, I have just kind of, slide number, I have put it here so that you can just go to whichever slide that interests you. That's how I've just prepared it. That will just help you out. Now, in BRSR, what they have done is, I'm sure you may have read it by now, that the ESG disclosures for value chain, they have deferred it by a year. So hence, ESG disclosures for value chain shall apply from financial year 25-26 as against the current requirement of financial year 24-25. And assessment or assurance also has become applicable from financial year 26-27 instead of the current financial year 25-26. So this is a very, very important change that has come. And providing ESG disclosures for value chain shall be voluntary instead of the present requirement of comply and explain. Who better than us professionals understand comply and explain? That how we saw CSR thing started by comply and explain. But now providing ESG, they have said it is voluntary instead of the present requirement of comply and explain. Now you kindly see point number 3. That's very important. That reducing the scope of value chain to cover the top, upstream and downstream individually. This was already there, individually comprising 2% or more, etc. That was then, it was actually covering 100%. But now it goes on to say that while providing that the listed entity may limit disclosure of value chain to cover 75% of its purchases and sales by value respectively. So that's quite a welcome change. And in leadership indicator, they have also included principle 6 of BRSR for disclosure of green credits. So whenever you go to this presentation, you can click on the link. It will actually take you to what are the changes that has happened by way of including this leadership indicator. Okay. And as I told you about substitution of assurance with assessment or assurance, then there is a review of, okay, I think I just need to tell you this. Just give me a minute. Assessment, this is very important if you may kindly take note. Assessment will be third-party assessment, okay, undertaken as per standards to be developed by the Industry Standards Forum. And this would be applicable from financial year 24-25 and financial year 26-27 onwards. Third-party assessment. Okay. Now, review of SME framework. Very quickly, if I have to tell you that SME IPO is, of course, we are seeing, and I quite deal in it in details. And I have seen how it has become such a darling of the market and of the investors. And as for this SME IPO, SEBI is quite hell-bound to actually, I'll not say contain it, but also to make sure that the market is quite matured enough to take it. And there are some checks and balances which needs to be included in the market so that only credible companies come into the fray. In that direction, what they have now done is that they have said that only those companies can come which has an operating profit. Operating profit means EBITDA of rupees 1 crore from operations for any 2 out of 3 financial years. Previous financial years at the time of filing is DRHP. And offer for sale previously could be done up to 100%. I'm sure you're aware, but now it has said that offer for sale shall not exceed 20% of the total issue size. I am sure you're aware what you mean by offer for sale. Offer for sale is actually being done by the promoters, okay, who hold shares. So offer for sale by selling shareholders. It's not the company. So mark the words. Offer for sale by selling shareholders in SME IPO shall not exceed 20% of the total issue size. And selling shareholders cannot sell more than 50% of their holding. So which means the government also wants to make sure that there is skin in the game of the promoters and the promoters group, and that skin in the game remains intact. It should not be that you're just making a public issue, making your money, and you're going out of the system. That will not be allowed. And therefore, if you see point number 3, as I just told you, and this is quite a welcome change, that lock-in on promoters holding held in excess of minimum promoter contribution. As I'm sure you're aware, minimum promoter contribution is about 20%. So it says that how the lock-in on the excess promoters holding will take place, which means they are not saying that you'll be allowed to just offload your shares the moment there is there is a listing. It goes on to say that there will be lock-in, and how that lock-in will be released is also given in this new change. It is to be released in a phased manner. That is, lock-in for 50% promoters holding in excess of minimum promoter contribution shall be released after 1 year, and lock-in for remaining 50% promoters holding in excess of MPC shall be released after 2 years. Okay. Allocation methodology for non-institutional investors will be aligned with methodology used for NIIs in main board IPOs. So we are aware that when there is oversubscription, and generally when there is oversubscription of more than 10 times, etc., we have always seen that the allotment is being done by the machine. It is a lottery system, and the numbers are picked up by machine. There is no human intervention at all. So it says that that is how it will be done in cases of oversubscription. Very, very welcome change that has happened in point number 5. In point number 5, where it goes on to say that amount for general corporate purposes shall be capped to 15%. It was previously 30%. Now they have made it 15%. And it goes on to say that, or just 1 minute, being raised by the issue, or rupees 10 crores, whichever is lower. SME issues shall not be permitted where objects, please mark this point number 6. SME issues shall not be permitted where objects of the issue consist of repayment of loan from promoter group, or any related party from the issue proceeds, whether directly or indirectly. Actually, a lot of these cases where government was seeing that the issues are coming out because of, and they are writing as the object of the issue, that the issue proceeds will be used in repayment of loan which has been taken from the promoters or the promoter group or any related party. Now, this has been amply made clear that if that is the objective of the issue, it will not be allowed at all. It not even writes 10%, 20%. It says that it shall not be permitted, period. Okay. Then DRHP of SME IPO will be made available for 21 days, and then go on to say by making public announcement in newspaper with the QR code. So they don't have to look in 5-10 places for the document. Immediately by looking at the QR code from their phone, they will be able to access the document, and it will be kept open for 21 days for public comments. A lot of times we saw in the past that there were comments coming even in the morning, okay, when the issue was just about to open, or just when the gray market was culling it, and also when the order book was being readied. All these cases, now it is being said that it will be kept open for 21 days for public comments, etc. Okay. Now, related party, please see the last point, point number 9. And also point number 8, very important, that further issue by SME companies to be permitted without migration to main board, but it will be allowed. But what it says, that the issuer has to undertake that all the provisions as applicable to main board listed companies will then be applicable for SME listed companies, is what they are trying to tell you at point number 8. So further issue by SME list companies to be permitted without migration to main board, subject to the issuer undertaking compliance of the provisions of LODR as applicable to the companies listed on the main board IPO. So this is very critical. And point number 9, related party transactions as applicable to listed entities on main board is being extended to SME listed entities, when provided that the threshold for considering RPTs as material shall be 10% of annual consolidated turnover, or rupees 50 crore, whichever is lower. So we need to take care of this. This is very critical, because otherwise, we knew that there's a lot of relaxation in handling related party transactions as per the LODR. But because of this point number 9, that is going away with. Now, merchant banker regulation, very quickly. First, let me give you an overview. In merchant banking, the basic changes that has occurred is now they are talking of category 1 and category 2. Category 1 and category 2, they have earmarked and they have mentioned that what will be the amount of net worth that they have to maintain, and what is the amount of liquid net worth that they have to maintain at all given times. They have also mentioned that what category 1 can do, merchant banker can do, and what category 2 merchant banker can do and cannot do. They also have gone ahead and said that these merchant bankers will not be now allowed to take up all activities under one umbrella. They have to segregate and make two different companies, one which will only deal with the merchant banking license, where they are talking about the issuance of securities, etc., handling them, underwriting. But suppose if the merchant banker is also doing valuation work, just for an example, because merchant bankers are allowed to do that, they are saying that within 2 years of this notification, whenever it gets notified, within 2 years they have to make sure that those activities are hived off to a new entity. And that new entity will not be allowed to use the trademark or the name of the umbrella entity. Okay, that also needs to be made sure that that same name is not used. But it also goes on to just give a leeway and say that you can use the common paraphernalia, that is the infrastructure, but all has to be quite segregated, etc. So these are the kind of changes that has occurred. Very quickly, let us read it. That activities other than permitted activities by MBA's merchant banker shall be hived off to a separate legal entity with a separate brand name. Look, it writes, with a separate brand name within a period of 2 years. Merchant bankers which have to hive off activities and the hived off entity shall abide by such code of conduct as may be specified by SEBI from time to time. The separate entity may be allowed to carry out activities other than the permitted activities by sharing the resources with the MB, but on an arm's length, without casting any legal liability in respect of the same on the merchant banker. And you may kindly look at this. This is very pertinent, that merchant bankers shall not undertake fresh valuation activities as part of its merchant banking registration. However, existing valuation assignments taken up by the merchant bankers may be completed. If a merchant banker wishes to take up valuation activities, it shall obtain registration from the concerned regulator or authority within a period of 9 months. There will be two categories of merchant bankers based on net worth and activities. Category 1, net worth not less than rupees 50 crores and allowed to undertake all permitted activities. Category 2, net worth not less than rupees 10 crores and allowed to undertake all permitted activities except managing equity issues on the main board. Right? I hope I've been able to make this clear from the slide also. And merchant bankers shall maintain a liquid net worth of at least 25% of the minimum net worth at all times. Now, I have hand signed the regulation 7. When you open it at your end, you'll be able to see that. So this is very, very critical. Okay. Look at this. The underwriting limit for merchant bankers, point number 6. The underwriting limit for merchant bankers has been prescribed as 20 times of liquid net worth. We never saw that any limit was there, but now it categorically says that the underwriting limit for merchant bankers has been prescribed as 20 times of liquid net worth. Now, I want you to see this slide a bit, and then maybe, we will have to stop in 5-10 minutes. See, at point number 5, I think this is a very new kind of a thing that has been brought in, and we'll have to really pop out our eyes to really see this and also take care of it. It will be mandated. So the language is, it will be mandated for merchant bankers to earn revenue from permitted activities as given below, failing which registration as merchant banker shall be liable for cancellation. Category 1, earn revenue of at least rupees 25 crores on a cumulative basis in 3 immediately preceding financial years. I'm sure it will be coming up as a future thing. So, and category 2, it says earn revenue of at least rupees 5 crores on a cumulative basis in 3 immediately preceding financial years. Merchant bankers managing only the issue of listed or to be listed debt and hybrid securities shall be exempted from complying with the aforesaid requirement of minimum revenue. So these are very, new changes that is coming. And then it has also talked about how to curb conflict of interest, and it has made it very, very viable. It doesn't look very, very tardy at all. And here, in merchant banking companies, minimum educational qualification of company secretary or graduate degree in law and post qualification work experience of 2 years has been prescribed for the compliance officer. So this is also a very welcome change that has come. It has started speaking about what should be the minimum qualification for a compliance officer. But it goes on to give a leeway that existing compliance officers may continue, provided they have 5 years experience and have obtained the prescribed NISM certifications. Okay. Now, there have been many changes that has been brought out in securitized debt instruments and security receipts, which I have put it up in the slides. The blue ones are the changes that has come, which you can see it at your end. There have been measures and reforms which has been brought about in Debenture Trustees regulation, and it has been made. It has been quite made. It has been kind of straightened, if I may use that. And a lot of these provisions that has been straightened means that the market should be aware how the debenture trust deed should look like. It has been quite made like a master document, and any changes that is being made by the debenture trustees and they are deviating from the master document as prescribed by SEBI, they have to, notify, they have to tell the client as to these are the changes they have made vis-a-vis the master document, etc. So debenture trustees roles have been defined and all that has really been, it's quite a good document that they have come out with. And they've also said that debenture trustees will only do activities which is falling under the purview, and they'll have to hive off the non-regulated activities to a separate entity within 2 years from the date of notification. For ease of doing business, ESG reporting, ESG rating report, they have said activity-based regulatory framework will now come up. And for high-value debt-listed entities, there have been certain changes that has come. The best change that has come for this is the threshold limit has been increased for identification of high-value debt-listed entities, and that the increase has been substantial. That is from rupees 500 crores to rupees 1,000 crores, and people are very happy with this. And they are introducing a new separate chapter. Now we know that in the LODR, we have to read that, okay, this is also applicable for HVDLE, and we have to find out and then comply. Now they say that they will introduce a separate chapter. And when that is done, the sunset clause will be introduced for the corporate governance norms, which is intertwined in the LODR regulations. Then they'll be giving increased flexibility in the constitution of the committees as given in the slide, etc. And they also go on to say that now, like independent directors who are getting appointed in companies whose HVDLE is listed, they are not counted in the limit of directorship. But now they go on to say that while counting, this will also be included in the computation. Okay, and they also say that for HVDLEs, business responsibility reporting system, they are trying to introduce on voluntary basis so as to introduce the practice of good governance. Now, for REIT and INVITs, that is the infrastructure investment trusts, quite few changes has come up. I have put up the consultation paper with the hand sign, and you can actually go ahead and see it. SM REITs is now, I'm sure you're aware, SM REITs is a very new area. We are doing quite a lot of work in SM REITs, and it's very, very interesting. You should actually look at it. It's a very new area which is emerging, and I'll request Taxmann also to do a session on this. So now the document has been standardized and disclosures has also been made into two parts. One is the key information of the trust, that is KIT, and key information of the scheme, etc., and so on and so forth. Lot many changes has come in the asset management companies. Then there have been changes in the mutual fund regulations. I have put up all of that. There have been changes in the custodian regulations. And there have been a proposal for recognition of past risk and return verification agency. Just give me a minute. So this is the changes that is going to come in the PaRVA that will happen. And then they have assigned responsibility for the use of artificial intelligence tools. And they have said that, persons who are using this artificial intelligence, they have to take responsibility of that being used. So all those changes has come. Then they have also aligned the modes for payment of dividend for Demat account holders. And this is very simple. They have actually done away with all the physical stuff. And they say that, look at this, the first paragraph, the board approved the proposal for mandating any kind of payment, including dividend, etc., in electronic form only. And in case of return, dividend, etc., they say that there will be an obligation of the company to inform the Demat account holders by way of registered post And then they say that the companies and the depositories shall engage in a sustained campaign. Okay. And the amendment will take effect from a date subsequent to such sustained campaign. Then amendments to include unpublished price sensitive information. I think this is the one which you really need to see, but the changes are yet to come out with. But what I have tried to see is the paper. So please look at the consultative paper. There is where you will find that what more has been proposed to be included in the UPSI. Okay. So here I have put it as a hand sign. You may like to look at it. Now, enhancement of optional T+0 rolling settlement cycle in equity cash markets. So SEBI has introduced the beta version of T+0 settlement cycle on March 21st, 2024. Yes, this is 2024. Huh? Let's not mistaken it as 2025. It has already been introduced, is what I'm saying, the beta version of T plus, but it was only introduced for 25 scripts and limited brokers. And it was implemented for non-custodian clients starting March 28, 2024. What was the objective? Of course, to enhance the scope and efficiency. Now, in addition to the T+1 cycle. Now, what is it that I am telling you is now this has been expanded to top 500 companies by market capitalization. Market capitalization as on December 31st, 2024. Gradual inclusion will happen, 100 companies per month, starting with the bottom 100. Okay, starting with the bottom 100. Please mark my words. Participation, all stockbrokers will be allowed to participate, and they will be allowed to even charge differential brokerage for T+0 and T+1. Qualified stockbrokers must enable seamless investor participation with updated systems. And custodians and MIIs, they have to prepare systems for institutional participation, for institutional investor participation. And key enhancements, block deal window, dedicated T+0 block deal session. Please look at this, 8:45 to 9 a.m. in addition to T+1 windows and optional participation for investors. Okay. These are all operational guidelines, and applicability says January 31st, 2025. Scrip expansion, broker participation and operational guidelines. And by May 1st, QSB and custodian participation, block deal mechanism. Okay, so this is it. SEBI Market Master Circular has also come up on surveillance of securities market. Trading rules and Demat shareholding, I'm sure you're aware that trading has been introduced for TFT segment for 10 days with price bands for mergers, demergers, companies which has gone through mergers, demergers, securities which is directly getting listed from another exchange, or some which has got its revoked share suspension has been revoked after 1 year or more, and stock exchanges must verify company disclosures before trading happens. Then there have been some changes in insider trading regulations, which I have given in the presentation. Thank you so much for this patient hearing. It has been 1 hour of constant dedication from your side too, for which I'm very grateful. And I'm also very grateful to Taxmann to really have invited me for this session. If there are any questions that has come up, I'll be happy to answer. The changes that has been highlighted in the board meeting, are those already in effect, or that is just an indication? No, that has already come into effect. That is one question that has come, that has already come into effect.